Think about the last time you had to make a big decision, like buying a car. You probably looked at the whole picture, the safety rating, the fuel costs, and the emissions. If you only looked at the top speed and ignored the missing seatbelts, you'd be setting yourself up for trouble. For decades, the New Zealand government made sweeping decisions about our environment exactly like that. When deciding whether to issue permits to drill for oil and gas, they effectively put on blinders. They focused exclusively on the potential dollar signs, narrowing their vision so the climate costs stayed out of frame. A student-led group called Climate Clinic saw this narrow approach and realized it was a systemic problem. They decided to take the government to court to challenge the way these choices were being made. In court, the government defended themselves using the Crown Minerals Act. They pointed out that the law tells them to promote mining for the benefit of New Zealand. Their argument was that the law already assumes that digging up fossil fuels is automatically good for the country, no questions asked. Because the government treated benefit as a settled fact, they didn't have to look at any data regarding carbon emissions or rising seas. This created a gap in the law where a decision-maker could legally sign off on a project while ignoring the physical destruction it would eventually cause. To understand why this matters, we need to look at what an exploration permit actually does. It's the essential first step that grants a company the exclusive legal right to search for oil. Once that company finds a resource, the system is designed to lead them directly toward full-scale extraction. These legal documents eventually lead to an industrial reality that spans the horizon. We're talking about 4-story offshore platforms and extensive onshore drilling sites that pull thousands of barrels of fossil fuels out of the earth every day. So, how did the government justify ignoring the climate when signing these papers? They argued it was someone else's responsibility. They claimed that monitoring emissions was the job of other environmental laws, so it didn't need to be considered at the start of the mining process. But by the time those other laws kick in, companies have already spent millions of dollars on infrastructure. If you ignore climate change at the very beginning, you lose the ability to stop the damage once the heavy machinery is in the ground. This dispute eventually reached the highest level, the Supreme Court of New Zealand. And the court completely rejected the idea that benefit was a settled fact. The court clarified that, for the benefit of New Zealand is actually a strict test. You don't get to assume drilling is good for the country. You have to prove it's helpful when weighed against everything else. To pass that test, the court established a mandatory consideration, a legal requirement they must follow. Before handing out a permit, they must check their decision against New Zealand's 2050 zero-carbon targets. This legal shift forces the government to look at the wider world. By connecting local drilling to the national atmosphere, the court ripped the blinders off. Fossil fuels directly drive global warming. The ruling made it clear. A government is failing its legal duty if it doesn't weigh that climate reality before granting a permit. The court also highlighted a second requirement, the Crown's duty of active protection under the Treaty of Waitangi. This is the government's legal obligation to go out of its way to protect Māori land, culture, and interests from being harmed. In the past, the government only applied this rule locally. If they wanted to allow drilling in a specific area, they would only ask the iwi who lived right next to the site if they were bothered by the project. This narrow strategy breaks down because air pollution doesn't stop at property lines. Greenhouse gas emissions float into the atmosphere and affect the entire country, regardless of where they were first released. We can see the results in the severe coastal erosion, washing away roads and threatening ancestral lands across New Zealand. Climate change isn't a local issue. It's a national threat to Māori treasures and heritage. This means active protection can't just be a conversation with the neighbors. The government must consider the disproportionate impact of climate change on all Māori, nationwide, before allowing more fossil fuels out of the ground. Now, here is the surprising part. Even though the government made those procedural mistakes, the Supreme Court did not actually cancel these specific oil permits. The court found that because the government had already banned new offshore drilling in most of the country, they had effectively weighed the climate enough for this one particular round of onshore permits. This decision points to a concept called the just transition. We have to move away from fossil fuels, but doing it overnight would destabilize the economy and cost thousands of people their livelihoods. We still need to keep the lights on while we build enough renewable energy to replace the old system. Protecting the stability of the energy grid and the jobs of everyday workers are legally valid reasons to manage the phase-out carefully. A just transition isn't an excuse to keep polluting forever. It's a temporary bridge. It's a managed plan that ensures New Zealand reaches a clean future without leaving entire communities behind in poverty. Climate Clinic didn't stop these two specific permits, but they won a victory that changes the future of New Zealand law. They established a rule that every future government must now follow. This pristine coastline is the reality the law now works to protect. We've moved past the era of blinders and narrow vision. The blinders are off. The courts have made it clear that climate change and nationwide treaty rights are no longer optional thoughts. They are now at the center of the process. From now on, any government that wants to develop New Zealand's resources must first pass the ultimate legal checkpoint, proving their decision won't cost us our climate or our commitments to Māori.
Stop fighting.